What's Freedom Lover talking about?
Museum of Sex.
Yeah. You get to a certain age, you got to go to a museum to enjoy it, right? Hey, good morning, everybody. Today is Thursday. Yesterday, when I announced it was Thursday, nobody said, no, it's Wednesday. I woke up this morning thinking, wow, is it Friday already? No, it's Thursday. We'll have another Thursday. Lots going on in the world today. Hope you're not trying to watch us via AT&T. Apparently, major power outage. How dependent are we on AT&T and electronic communications? According to a story in the New York Post, they had 30,000 complaints at around 4:30 this morning. Who's even up at 4:30 thinking about using the phone? 911 calls were disrupted, and of course, yeah, I know you are, Mike. And of course, my thoughts immediately turn. Have the Chinese finally done us in? And apparently not. At least I don't see anybody wandering across my meadows with chopsticks and a bowl of rice, saying, "You must eat us now." So, good morning, everybody. Lots going on in the world today. I don't even know where to begin. I'm glad I'm not Mike Lindell. So, Mike Lindell, prove me wrong. I've got data here that shows the Chinese interfered with the 2020 election. I'll pay $5 million to the guy who can disprove it. Mike, what happened?
Well, back in 2021, Lindell put together some sort of symposium, and the point in the symposium was to talk about the data that he had, these packets in his possession that would show that the Chinese interfered in the 2020 election. That there was election interference on a scale that was so identifiable based on cybersecurity experts that he spoke with that one would necessarily be able to, if they had the right skill set, go in and actually see, for example, Tampa, Florida, and say this many votes were tabulated erroneously, et cetera, et cetera, et cetera. He held this symposium, and at the symposium, it was an invite only. You had to be vetted before you were allowed to come.
And that explains why I didn't get to go. Okay.
Well, and at the symposium, he also announced a contest, a prove Mike wrong contest, in which participants could sign up for free or enter the challenge for free. And there were contest rules, and the contest was something to the effect of if you once we divulge to you these files that we have, these packets of data and information, are able to show that they are not that there is no evidence of Chinese election interference, or that they are not sourced to the 2020 election, that this data is not tied to the 2020 election, you will win $5 million. And the contest rules provided that any disputes arising under that contest were to be submitted to the American Arbitration Association. And so what transpired thereafter is one of the gentlemen that entered the contest. Let me see if I can pull up his name. I actually have the arbitration decision here from the commercial side of the American Arbitration Association. His name is Robert Zeidman. So Zeidman is not only a two-time Trump voter and Republican, but according to the background here, Mr. Zeidman has a master's degree in electrical engineering, an undergraduate degree in physics, and over 45 years of experience in software development. He holds over 24 patents in computer software, hardware, communications, and similar fields, and he served on many occasions as an expert witness in intellectual property cases involving computer software and hardware. So perhaps the wrong person for Lindell to want to enter the.
Yeah, no, I mean, what was he thinking? So did he have this material? Lindell, that is, the founder of MyPillow and, right-wing figure who has his own world of financial difficulties independent of this right now. But I mean, did he have this vetted? Or is this another case where, I'm looking at the data and my experts tell me, but there really weren't experts. And what's more, how did he end up in an arbitration situation? And what is arbitration? I mean, let's break that down for people. You and I know what it is, but.
So arbitration is a mechanism by which parties can submit their disputes to a venue other than the court system. So it's private. There's a separate there's a and it's legally binding. So arbitration should not be confused with mediation. Those are two very distinct remedies between parties. Mediation, the latter, is something that can still be appealed and submitted to a court. But typically, arbitration decisions are legally binding. So whereas mediation is more of an advisory opinion and parties should dispute, and something that is highly sought after in today's world, people just want some sort of semblance of equity or a fair way to go about,
Well, and also they don't want to have the delays of a jury, and juries can be fickle. I mean, presumably in an arbitration and mediation context, expertise matters some. So are you saying Lindell contracted his right to have this dispute solved by a jury? I mean, first of all, I guess it was a binding contract. He made an offer, somebody accepted it, and now Mike doesn't want to pay, so they go to arbitration, and they say, yeah, this was offer, this was acceptance. I mean, what happened here?
Yeah, so Zeidman entered the contest, and the contest rules stated a number of different things. But number one, that the data needed to be shown to be not quote from the November 2020 election. So it was a pretty narrow window, and the arbitrators it was a 3-arbitrator panel here, and they went through the contest rules and meted out some sort of vagary or ambiguity within the terms of the contract, but ultimately found that these terms were unambiguous, that the parties were actually in lockstep with their understanding, so they didn't need to bring in what's called parole evidence or evidence from outside of the document. And
spoken evidence, non-written evidence, right? Yeah,
right. And interestingly, this is, I think, what you're getting at. I'm going to read. So there's a section in the arbitration decision that says the red team prepares the data. Lindell LLC, which is the defendant here, assembled the Red Team, a group of software professionals, to review the data that would be presented to contest participants. Members of the Red Team protested that the data was not at all what they expected. So these are people that are supposedly on Lindell's side of the fence here. They had expected to be provided with a packet capture data that could be examined and authenticated to evaluate whether the data files provided were genuine or had been tampered with or altered. And then the arbitrators go through this a little bit about what it means, what is packet data, what it means to be encrypted, decrypted, what sorts of tools wouldn't be necessary to decrypt or unencrypt data that is encrypted, and ultimately how to tell whether stuff is tampered with or whether it's raw data that is direct from the source. So primary source information. Josh Merritt, who I believe is a pretty well-known quantity at least in the X space, was part of the Red Team. And he explained that none of the Red Team cyber experts were actually able to open the files and obtain the packets that the Lindell team provided. And he testified further that he had told Lindell to call the contest off because of that. It gets even worse. So what Lindell's team actually did is present, I think, some small fraction of the total amount of data. And then they did several things here. So, and this is, I want to read this because I think that this is interesting. Lindell, so he explained that the data was generally prepared for the contest participants. So prepared is what's under the scope here. First, he said there was too much data to provide to all the participants. So they were only giving a slice of that data. They believed that they needed to be sure to avoid providing sensitive private information, right? So then they didn't give them that. And then they were putting in ciphers, right, within the data. So actually implementing new things in the data, new hurdles in the data to see if participants could actually demonstrate their sleuthing skills. And then some of the data was actually presented in encrypted form and could only be using this stuff called a C extractor, a software tool designed for that purpose. Well, anyway, Zeidman, being the guy that he is, provided a report, and he concluded after analyzing the files that he won the contest, right? That
the data was gibberish, basically.
That the data Lindell provides, this is in quotes, and represents, reflects information from the November 2020 election, unequivocally does not contain packet data of any kind and do not contain any information related to the November 2020 election, right? And so based on that, in the contest rules provide that the Lindell team, in its sole discretion, can put together a team of experts to sort of mete out any discrepancies between the parties' conclusions as to a report. And of course, Lindell's team, or Lindell himself, refused to honor his promise, and his claim was that you just didn't meet the standard. your report, your conclusion doesn't meet the standard. So Mr. Zeidman, which I have a newfound respect for this gentleman, because what I'll get to in a minute is more about the claims for relief. But his intent here was really just to challenge his own view of the 2020 election. He actually went to the symposium and indulged this contest because he wanted to see if there was something that could confirm or overturn what his preconceived notions were about the election. And at least with respect to this narrow issue of whether this data provided by Lindell, who Lindell had a huge microphone, he's blasting this stuff to all over
Lindell would drink some of Sidney Powell's Kool-Aid. Let's face it. I mean, they're both, I think Dawn nails it. Nutso, harmful nonsense.
Well, so ultimately what he says is that, okay, well, I'm going to take this to arbitration. The arbitrators awarded him the $5 million, and they did so based on just a simple breach of contract theory. First, they had to go through what you and I went through earlier this week, which is there a legally binding contract? Did the parties perform as contemplated under the contract? And did one of the parties breach its duty or its obligation to provide the consideration to the other? And here, it was, again, the arbitrators were not trying to determine substantively whether there was interference in the 2020 election or whether there was Chinese interference in the 2020 election. The arbitrators were narrowly charged with determining whether the call of the contest was answered sufficiently by Zeidman, and they concluded that yes, it was, and therefore Lindell is obligated to give the $5 million. Well, Lindell appeals this arbitration decision, and the news today, 2 years later, 3 years later, is that Lindell is obligated to pay the $5 million. Now, I'll say this, and here's why I actually see Zeidman in a positive light. We get down to the actual, and I'm sorry, I'm going a little longer than we wanted to, Norm, but the Minnesota Consumer Fraud Act and the unconscionability claims are those secondary to the breach of contract. And as it relates to the Minnesota Consumer Fraud Act, Zeidman actually said that he would not even pursue a violation of the Minnesota Consumer Fraud Act as a mechanism of getting a remedy if he prevailed on his contract claim. And as a result, attorney's fees in Minnesota are typically only provided unless otherwise agreed by the Consumer Fraud Act in cases of contracts like this, right? So what he did was actually a service to Lindell, because he could have still pursued a violation of the Minnesota Consumer Fraud Act, still sought attorney's fees and costs above and beyond that to get everything back. So what he did is ultimately just go directly through and say, I performed, I should get the money. Right. And I'm not going to punish you, Lindell. I'm not going to make this a gratuitous litigation. It was Lindell that put it into the appellate level. And I think, according to the Washington Post story, Norm, he says he's been quoted as saying that he doesn't expect to ever see the money, but it feels good. And that he encourages people to always challenge their own, closely held beliefs about certain things. And this was an exercise for him to do so.
And a costly exercise for Mike Lindell. Hey, so all eyes in Austin, Texas. Let's talk about jury selection. A couple police officers are charged with manslaughter for causing the death of an arrestee, a Mr. Ambler. And so in jury selection, under the Sixth Amendment and the various state constitutions, you have a right to a jury trial, and you're supposed to get a fair cross-section of the community. Well, what does that mean? Typically, when you pick a jury, you bring in strangers into a courtroom. They're summoned, and they are presented with the bare facts of the case. And they are asked, can you be fair and impartial, knowing what you know about this? Depending on the jurisdiction, there's some questioning by the judge, perhaps some by the lawyers. And jurors are voir dire. They're supposed to speak the truth about their views so that a jury can be selected of people who can be fair and impartial. That doesn't mean that they know nothing about the case. That's a common misconception. But it does mean that whatever they've heard about the case, they can put aside and render a verdict based on the facts as they are seen in the courtroom and the law as instructed by the court. Lawyers have a chance to challenge whether lawyers can be fair and impartial, and those are called those are called peremptory challenges, not preemptory challenges, as some of you around the country say, but peremptory, Peremptory. A peremptory challenge can be used if a lawyer just has a spider sense that this juror is not going to be right. They're looking for something else. However, in an unfolding series of cases over the last several decades, limits have been placed on the use of peremptory challenges, and lawyers, when challenged, must give an account of how they've used them when they use them against people in protected classes, such as African Americans. Ambler is black. The officers are white. They're assembling a jury in Travis County, and two black prospective jurors were bounced from the panel. The defendants used peremptory challenges because this isn't what they were looking for. Well, what's this? Was it black jurors? The prosecution suspected it was. They challenged the use of the peremptory challenges, and the trial court said, no, there were valid reasons for not wanting these folks, valid reasons independent of race. This is going to provoke a huge discussion in legal circles about how race counts or matters or should matter in jury selections. There are those who want to eliminate peremptory challenges altogether on the grounds that a dissembling lawyer can always cover his or her tracks and hide the true reasons for striking a juror from the panel. And some will say that an all-white jury cannot render justice when a white police officer is involved in the death of a black man. This week, folks, I want to hawk this book again. I made more progress in it last night. This probably is one of the better reads you'll have for the year. Yasha Munk, I didn't know of him until this week. The Identity Trap. Basically, he unmasks why it is we're so preoccupied with identity, and basically says that, this brave new world of ours where we've abandoned neutral principles and held that the only way to be an anti-racist is to be a racist means that you've got to give things to oppressed identities in the name of equity. You've got to give them preferential treatment. And so expect the BLM, Ibram X. Kendi crowd to look at the Ambler case as proof positive that we must have black seats on jurors, because black people just see the world differently than white people, and white people will never be able to understand or comprehend the black world, and justice won't be done. Independent of however objectively reasonable the use of force was against Mr. Ambler in Texas, black eyes would see it differently than whites, and there is a gap so profound as between the identities and the races that the only way justice will be done is if we assure a diverse jury. Implicit in that argument is a destruction of anything like a community, is the death of the West, because what it basically claims is that we are all idiosyncratic bearers of our own particular truths, and there's no truth that we can share in common. Justice is in the eye of the beholder, and a black man is going to have a different sense of justice than a white man. And in order for white officers to be judged in the killing of a black man, we must listen to black voices, because they'll see the world in ways that are altogether different and that will inform our sense of justice. I get that up to a point, but it approaches a vanishing point where we end up with what amounts to special pleading and what amounts to the use of identity as a pawn for in the search for power. And I think that's what really identity politics is. Everybody wants a leg up in the marketplace, and if you can make your skin color or your identity or your preference or your idiosyncrasies valuable in the marketplace, your exchanges will prove to be more beneficial for you. I think that in the context of a jury trial, pandering to identity is toxic to any sense of community. And I'll be curious to see what happens in the Ambler case. I don't know a whole lot about it. The story caught my eye, though, because I see it as a firestorm in discussions about jury selection and how to select jurors.
Don's question and comment here, I was hoping we would get to, because saying that the absence of black jurors in this case is going to be determinative of guilt or innocence of the charged parties is, yet to be proven, right? But what you and I know, Norm, and you more so than me, is that jury selection is both an art and a science in and of itself that's widely and commonly misunderstood, and also human nature is very difficult to suppose in the justice process. Dawn says, a rational judge, wow. Aren't men more harsh in rape cases than women who blame the woman more often? Same for whites, white guilt. And before you go on, I just want to read from the article here. It says that there was a 95-person panel, right? So 95 potential jurors for this case. Only 6 of those were black. 3 of the 6 were deemed ineligible by the court for reasons that we're not going to discuss here. 2 of those were struck by defense, and 1 became an alternate juror. So we're talking about 6 potential out of 95. 3 of those who were ineligible, legally ineligible, not substantive determination, but legally ineligible. So 3 of 92 potential. And then of those, of the 12 available seats, right? 1 became an alternate juror and 2 were struck by defense attorneys. Now, there's argument, and I think it's kind of crazy here, that there's argument over what the racial composition is of the jury that has been selected. The prosecution is saying that there are 10 whites, right? And the defense is saying, no, there's only 6 whites. Or 10 whites, right? Sorry. So, the prosecution is saying there are 10, and the defense is saying, I think, 8. There's even a discrepancy in the way that the two sides even label white or not white, which is primarily the issue here. Is it not? Is it not the issue more narrowly that this is about how many white jurors are on the jury or seated on the jury, rather than how many or not black juries or jurors of color are on the jury?
I mean, yeah, I don't know. Candidly, the whole debate is chattering gibberish and nonsense. And those who are participating in a courtroom should be ashamed of themselves. Here is everything you need to know about jury selection. And I've selected hundreds of them over the years. It's all about one thing and one thing only. Ready? Bounce. The key to jury selection is bounce. What am I talking about? You walk into a bar one night in a strange town. You want to get something to eat or have a drink. You're visiting. You're at work. The place is packed. You grab a seat. You end up talking to someone in the jury or in the bar. How did that selection take place? It took place as a matter of bounce, of attraction. You were drawn to another person. Another person was drawn to you. They were prepared to listen to you. You were prepared to listen to them. When you're standing on your feet in the well of a courtroom picking a jury, all you want is a juror who is going to listen to what you have to say and give you a fair shake. And that is the beginning and the end of jury selection. In Connecticut, we have an unusual manner of selecting jurors. You question each juror out of the presence of the others and can speak to them for an unlimited period of time. Sometimes there are some lawyers who take an hour with each potential juror. I usually know within a matter of a couple minutes whether I'm going to pick a jury. Why? It's the same way that I might gravitate to the bar stool next to you, Mike, because I know you're a listener. I know you'll be open to the claims I have to make. When you go into trial, you have a theory of your case, what it is you intend to prove or disprove. You're looking for people who will give you a fair shot, who haven't decided against your case based on you or your characteristics or your client's characteristics or the type of case it is. That, ladies and gentlemen, is the beginning and the end of jury selection. The notion that we need color-coded, gender-coded, libidinally coded, identity-coded jurors in a particular mix to render justice is toxic to the very idea of justice. There are neutral legal standards that are applied to strangers in conflict. Jurors are to apply those standards to the facts as they find them and render a verdict independent of their passions, independent of their perspectives, independent of their biases. When we go about selecting jurors because of the perceived biases they'll have or the perceived perceptions that they'll have, we're not looking for justice anymore. It becomes sort of an assembly line enterprise that will undermine confidence in the jury system. So the debate about who is white, how white is white, this, that, and everything else is ridiculous, and shame on Austin, Texas for getting involved in it.
Well, and just to give a little more light to Dawn's question and her point about, men tending to be more harsh against men in rape cases than women who tend to blame the alleged victim. right? And results in the way that they'll vote based on that, and the notion of white guilt. I just think, the proposition there that I was trying to tease out, Norm, is that attorneys don't necessarily know, and that's why I think what you're saying about bounce, or I think younger people would say vibe, right? It's
No, bounce.
you're looking to establish rapport with the
Yeah.
juror, right? But what ultimately there is no telling, and this is why it's usually advised that in the on university campuses, right? When someone who is subject to some sort of disciplinary proceeding is offered the ability to go before a panel of their peers or a student conduct officer, a single student conduct officer, it's more often advantageous to do the latter, even though most people would intuitively think, and mistakenly, that a panel of your peers is going to be somehow more, you'll be able to ingratiate yourself and identify more with them, right?
Man, that's just overthinking it. I mean, Dawn, to your point about women in rape cases, I've tried any number of rape cases and won most of them. And I just don't think of the gender of potential jurors. I mean, usually in a rape case, usually, consent versus he forced me kind of case, there's going to be a highly fact-bound determination about what happened in that fraught moment leading up to penetration. And not once in my selection of a jury have I thought, I need X number of men, X number of women, X number of men of color, or this, that, or the other thing. What I want are individuals who listen, because that's what I'm looking for, is a person who will understand the claims I'm making and fairly evaluate it. This whole racket of jury consultants and picking jurors and demographics, is ridiculous. It's ridiculous. So let's keep an eye on that. Hey, did I see? Is it Vivek? How do you pronounce that again? Did he make the short list? Who's on the Trumpster short list for VP?
First of all, we're going to refer to Rumble here on out as Tumble. Sorry, everybody over there struggling and suffering under the tyrannical regime that is, guided by delusions of grandeur as to its, the efficacy of its technology and infrastructure. It's, you can make another choice though. X is doing well, and so is YouTube.
What's up with Rumble? I don't see the feed.
It's glitchy. It's dropped off a couple times. People are now acknowledging that I'm not totally crazy. Anyway, Jackson saying Rumble is very glitchy. X is perfect. It is. So is YouTube. So if you're having trouble over there, come and hang out over here. We can also put your comments up on the screen from time to time. Anyway, so who's on the short list? Senator Tim Scott is on the short list. Kristi Noem, that dummy, is on the short list. Vivek Ramaswamy is on the short list. Tulsi Gabbard is on the short list. Who else? I think Ron DeSantis is also on the short list.
Is he serious about that? Or is he there just as a nod to diversity because he needs an idiot in there as well? Yeah.
Dawn says,
Dawn, the VP list is fake news. Yeah, I mean, what do you mean it's fake news?
I kind of agree, Dawn. I kind of agree. I mean, so the source of this story is Trump's appearance on the Ingram angle, I believe, and she asked him if these names were on the list. And of course, Trump, in typical Trump fashion, says something to the effect, they are, right? And then goes on to say, that these people are all solid, and gives a long soundbite about, I think, his most recent rally there in South Carolina, about the strength of one Tim Scott. So what I think is that perhaps this is a short list of expected candidates, and certainly those that are qualified, and I guess people would get behind to some degree or another. But I don't expect that anybody on that list is going to be ultimately who's named. I think, who said this? Junior says Carrie Lake. Why aren't we hearing her name? I think that Carrie Lake is probably the front runner in my opinion. But
I'll leave it alone. Well, I don't know. We'll see. I guess one of these. When do we expect him to make an announcement? I guess he's got to get the nomination first. But will he wait till the convention, or will he do it beforehand? I don't really have a sense of things.
I don't know. T's calling me a Fed. T, stop it.
Aren't you? Yes, I am a confidential informant for the Department of Homeland Security. And the reason we have this podcast is we want to draw those of you out who appear to be disaffected with the grand American narrative so that we can place you on a security list and put you in a FEMA registration camp the moment there is any sort of turbulence in the air. So keep responding, folks. We've got a comprehensive list. Junior Coltrane, you're getting a deep security cell in a camp locked away in a secret location, and you'll never see the light of day again.
Let's see. We've got the we didn't even talk about the sex stuff.
Oh yeah. Well, did you know there's a sex museum? This reminds me, I was in LA not long ago, and I'll be in LA again late next week. But I was in LA not long ago in the hotel, had a few minutes to spare, and realized that a couple blocks away there's a death museum. And I'm thinking, oh, that could be interesting. And then I took one look at the mirror and I said, man, I'm close enough to death. I don't need to go to a museum to look at it. But a sex museum? So apparently, an artist, she's kissing her ex-girlfriend. And the sex museum puts a picture of it up, and now she wants to sue and has sued. She wants $275,000 apparently for this publication of a private fact. That's one of the 4 ways you can quote unquote breach privacy. But here's a question: you're an artist. You're in the business of performing. You kiss someone in public. What did you think you were doing? This isn't exactly a spy cam in your bedroom watching you prepare your toilette. I mean, you're making out in public, babe, and somebody got a picture of it. If you don't want your intimate life in that form broadcast, then keep it private. We don't really need to see it in the first instance. Kind of a ridiculous suit, in my view. Am I missing something?
I don't think you're missing anything. I do believe that this is perhaps more about the publicity to be generated for this person outside of the merits of the lawsuit. The lawsuit says that the museum's revenues went up by use of this advertisement that was used for a while, and that people were messaging her on the side and saying that they recognized her in this photo. I think perhaps either there's one of two things. Lowest common denominator here seems maybe she's particularly vain and wants to use this to raise her profile for other reasons. That would be my vote. Also, it could just be that maybe you don't like having your image of whatever same-sex activity or just activity that is known to be intimate but is in the public life on a poster that says "Museum Make O Challenge" with a Wheel of Fortune wheel that has, like, I don't know, massage and whatever
Well,
else.
that could be. I mean, so there is a false lights claim of breach of privacy.
For
It's one
Funland.
thing to give a little peck. It's another thing to be held out as a lascivious slut for the world to see. And maybe that's her claim. Although there she is posing in front of the poster. So is she compounding the harm or enjoying the attention? Who knows? I didn't know there was a museum of sex in New York. I guess they have a little bit of everything there. I don't know that I'll be going.
Well, it seems to be, a frivolous lawsuit. And look, I mean, at $275,000 means that, that tells me that perhaps even the attorney that was willing to engage for this was having trouble coming up with some impressive damages calculations. It's, whatever they can reasonably allege, and then maybe discovery will out something. I expect this to settle and this to go away pretty quickly.
Well, we'll find out. We'll try to keep an eye on it, although something tells me we'll lose interest. She kind of looks like Lady Gaga, and that doesn't do it for me. So, anyhow, listen, tomorrow we're going to have a special guest. Mike, you rounded him up. We're going to be talking about reparations with one of your new idols. I mean, this is a young man you talk about often. Tell us about it.
So
Tell us.
Adam Ellwinger joined us last year. I believe it was in October, maybe a little later. It was whenever you went to you were at comedy camp for that.
Yeah, in October, right? Yeah.
And so we had, I think, Mark Meckler joined us, Mark Randazza joined us, and Adam Ellwinger joined us to talk about the southern border issue and the piece that he wrote at the time for the American Mind. He's got a new one. We talked about it briefly yesterday in the American Mind called Reparations by Other Means. So he will join us tomorrow morning at 8 a.m. and he'll be here for the duration of the stream. Norm will talk about his piece in the American Mind, the implications and the consequences thereof. And then also we know that Google's new AI technology, Gemini, has been released, and I'm reading more about how race conscious that AI is, and anti-white, frankly, I guess is the best way to put it. So we'll talk about.
Are you telling me that's why every time I use AI and I get an ad for Cracker Barrel, that's just not it? That's not random. They're targeting me as a cracker.
I love Cracker Barrel.
You would.
Hey, I get it honest. Anyway, so yeah, tune in tomorrow. That'll be a fun one. He is an hour behind us, so he'll be up at 7 a.m. for your stream. So, Junior, not quite as early a riser as maybe you are, but certainly good for us to have someone getting up at 7 a.m. to talk about what is a really impressive piece in the American Mind. So I'm looking forward to that.
Jackson T. Barrett, start earlier, program longer. Easy for you to say. Thanks for coming back. Thanks for coming by. Thanks for having us, folks. Look, here's my day. We get on the air 8 Eastern time. At 7, I'm usually doing psychoanalysis, where, I put the psycho in analysis and trying to figure out how it is that I can keep my life together amid so many conflicts and controversies. And then I get off the phone at 7:50, quickly scan what Mike and I earlier in the morning agreed to talk about. And here we are at 8. So it ain't going to be any earlier, Jackson, and longer. Mike and I have jobs. We have day jobs. This is an avocation. Of course, if you want to hear from us more, spread the word, have people subscribe and throw infinite wads of cash at us. We'll retire from the law, put our feet up, and tell the whole world how to think, when to think it, and when to get off. But, everybody's got a dream.
Indeed, they do. And if we get a few more of those, 80 subscriber in a day weeks like we had last week, I think, it won't be that long until maybe we can make the show longer and start a little earlier and maybe move your psychoanalysis to even earlier than 7 a.m., right?
Can I get reparations for past discrimination against women? Dawn McNeil says. Women procreated this country. Yeah, well, if you get reparations for that, I want reparations for helping you procreate. Everybody's entitled to reparations. Everybody gets a prize. All everybody wants is just to be taken care of, because let's face it, being pried away from mommy's teeth was a trauma that led us all to learn a second language, because at heart, we're all whiners, lost in sin. Read your St. Augustine, folks. Sin is love of the wrong thing, love of identity. You demand for reparations. That's simply a desire to be reattached to the eternal teat and to be supported in a world of woe. You've got to pick up your own bed and walk, folks. That's the message. Get it done.
Lawyer Will wants to know if you're in LA doing a case. And before you answer that, he also suggests that if you want an oddity, to check out the Museum of Jurassic Technology. What the hell is that?
I will check it out. Tell me more, Lawyer Will. No, I've got some comedy gigs out there, and I'm going to be working on some comedy routines because, after all, when I go to court and people laugh, my feelings are hurt. When I go to a stand-up comedy club and perform and people laugh, it works. So if the laughs are constant, shouldn't I go where the reward is better? Thanks, folks. We'll see you tomorrow.
See you tomorrow. AMF, yo-yo.